Oh, great. Take a seat. Okay, safe. Great. Thanks, Skip Rutherford, and thanks to the Clinton School. This is pretty remarkable. When I called them about this Monday morning, I thought, gee, surely 100 people will turn out and I won't be embarrassed. I hope perhaps this will be the start of something interesting, and Skip and I have talked about the appeal of perhaps periodic meet the press sorts of panels on major news events. I hope that can happen. But let's get right to it. Joining me tonight, first to my immediate right is prosecuting attorney Scott Ellington of Jonesboro. Just months into his first term in office, I might add, he negotiated the agreement that produced last week's dramatic developments in what we all know now as the West Memphis 3 case. We've moved around. To his immediate right, Mar Leverett, contributing editor for the Arkansas Times, author of Devil's Knot. She clearly needs no further introduction. At the far left, Cappy Peck, Little Rock restaurant owner. For those of you who might know, she led Arkansas Take Action, which was a grassroots group that worked in the West Memphis 3 effort. Then we have 3 defense lawyers who are active in the case. All are lawyers in Little Rock. First, at the far end, Patrick Benka. He represented Damian Eccles. In the middle here, Blake Hendricks, who represented Jason Baldwin. And finally, Jeff Rosenzweig, who represented Jesse Miskelly, Jr. I hope the discussion, once we begin, will be free-flowing. The panelists are welcome to comment to what others say and to interject remarks. I'm going to begin not with prepared remarks from each, but a question aimed specifically at each one of the 6 panelists as a means of sort of introducing them to you in the areas that they represent. I encourage them all, if they'd like to add other introductory remarks, by all means free to do so. I'd like to echo Skip. This is, first of all, an educational opportunity for the school and for all of us, and I don't think we shy away at all from controversy or contention, but I think we can do it civilly, and I hope you'll help me with that. If you haven't already gotten a copy of the Arkansas Times, and if there are any left, we have a great report this week on this case, and we had copies for free available outside. If you haven't got one, try and find one. One other small piece of news, we were able to round up a small number of Mara's book, Devil's Knot. She'll be outside in the lobby afterwards, and if you'd like to buy one, she'd be happy to sign it, I'm sure. Let me start just quickly with a brief summary of the case. It's probably unnecessary, but just to lay out the basic facts. On May 5th, 1993, 3 8-year-old West Memphis boys, Stevie Branch, Christopher Byers, and Michael Moore, were reported missing after school. Their bodies were found in a creek the next day. They'd been beaten and bound with shoelaces. On June 3rd, 1993, Damian Eccles, Jason Baldwin, and Jesse Miskelly were arrested. Jesse Miskelly was convicted February 4th, 1994. Baldwin and Eccles were convicted March 18th, 1994, and Eccles was sentenced to die. The other defendants were given life sentences. A round of appeals failed to overturn the verdicts. Post-conviction relief petitions continued. Worldwide attention came to the case from HBO documentaries, Mara's book, grassroots efforts, and in time, the formal networking of the internet. The big change in the case came last year in 2010 when, primarily because DNA testing was not possible at the time of the original trials, the Arkansas Supreme Court ordered an evidentiary hearing on the DNA findings and all other evidence, including information not heard at the trial, which I think we will hear later was a pretty significant ruling. That hearing was scheduled in December in Judge David Lacer's court in Jonesboro. Then last Friday, a bombshell in Judge Lacer's court. The state and the defendants appeared on short notice to announce an unusual plea agreement. The defendants would plead guilty to reduce first-degree murder charges and be released for time served with 10 years suspended. The terms of their plea, which we'll discuss too, allow them to continue to assert their innocence. So let's go now to questions and answers from the panel. I'm going to start with Scott Ellington. And I want to begin at the beginning of the case, and I'm sensitive to this. It begins with the victims. It begins with the children and their families. And I'd like to ask Prosecutor Ellington to tell us about how he informed the families of the agreement and how he explained to him that justice was being done by releasing the people who had been sentenced in this case.
Well, to start with, after the deal had been negotiated, and it took about 10 days to get this agreement hammered out between the parties. Once it became very real and very clear that we were going to do this on the Friday last, I needed to inform the victims. Understanding that this is such a difficult case, it's an ongoing, long case, I felt like I needed to not give them veto power, but to at least make them aware, because there would be press contacting them immediately. On Wednesday, prior to the Friday, I met with Michael Moore's father, Todd, at the Sheriff's Department in Crittenden County. Now, Michael's dad, Todd, is divorced from Michael's mother. He came in, and I sat down at her table with him, and it's very difficult to have a conversation with someone who has lost their child, and you'll understand that Todd is, you don't see much of Todd. Todd doesn't appear on many videos. He doesn't appear in much of anything as of late anyway. He's maintained his silence and solitude in this case. I explained to Mike this, or to Todd this, that the defense counsel and I and my deputies had met in Little Rock, and the defense counsel had offered to plead guilty to various counts of murder under the Alford plea, and that I know it's not something that we like, but that's what has happened, and I gave him further explanation. My understanding of the agreement is this, and the situation is this, is that Judge Laser will be having a hearing in December. The Supreme Court, in the November 4th, 2010 ruling, opened up all evidence. That's the big word that was key to us, all evidence that could lead to an acquittal. And I said, there's a lot of evidence out there. A lot of evidence has deteriorated. You understand that this judge is liable to grant a new trial. He agreed. And I said, if Judge Laser grants a new trial, considering witnesses have changed their minds and that one has died and some evidence is just deteriorated, and we didn't have DNA back then, I said, there's a good possibility that there will be an acquittal. So in our estimation, even though I agree with you that we believe that the defendants were the murderers of these children, we believe that the best interest of justice would be served if we entered into this agreement where they would plead guilty, and it's a peculiar agreement in that they can maintain their innocence, but they make certain stipulations, which you all are, I'm sure, aware of at this time, and then we'll go forward. Todd wasn't real happy about that. But he didn't raise a big fuss. We talked a little bit more. And his final words were, as much as I can remember, his final words was, well, it is what it is. You do what you're going to do. After I left Todd, got back and started trying to get numbers for the other parents. Got an email from him later that evening reasserting that his objection, but again, his last line was, it is what it is. And I took that. Again, I didn't give him veto power. I just wanted him to understand that I was sensitive to his loss and concern about his child. And the loss of a child has devastated his family in many ways, but that's the way we left it. I asked him about Michael's mother, and Todd said that he thought it would be best if he actually informed her as opposed to me, and I asked him to do so. And so we left at that. The next morning was Thursday morning, and that's when I, in earnest, began calling the other parents. I contacted Pam Hobbs and advised her of the same deal, maybe not as much in detail. I didn't feel compelled to try to find Pam and meet her face to face. She had left Crittenden County and moved to Mississippi County. But I advised her that, as Stevie Branch's mother, that what the deal was. She was not necessarily happy because, as most of you are aware, she has actually been on the defendant's side for the last couple of years, and thinks that the defendants did not commit this crime. So, but I gave her the same courtesy and the same respect as far as trying to be compassionate and explaining the deal. After that, I called John Mark Byers, who is the stepfather of Christopher Byers, but he was the contact that I'm aware of in this case, and had the same conversation. And he's so much milder and calmer on the telephone than I was like. I asked to speak to John Mark Byers, and he said, "Who is this?" And I said, "This is the prosecutor, Scott Ellington." And he said, "Well, this is John Mark Byers." And I said, "Are you okay?" And because he was just so calm, everything I've seen of him has been much more vocal. Anyway, he was, again, not very happy with, much like Pam Hobbs, when I explained what we were doing on Christopher's behalf in this case. But he accepted it, and he said he would be there and express his displeasure with this agreement, and with the state entering into an agreement that would have these defendants enter any kind of plea of guilty in this case. I called Pam back, and I felt compelled to call Steve Branch, and because it had been mentioned to me that he was Stevie's biological father. So I finally left messages, and actually Pam got a hold of him, and he called me at 1:15, I remember vividly, on that Thursday, the day before we had the plea agreement. And he was very upset, but I explained the deal to him the best that I could during our conversation. And Mr. Branch then just expressed his displeasure again and indicated that he was going to have words with other people. And I said, "Well, please, you're under a gag order." I reminded him of that as a family member. Got back to the office where Patrick and several other lawyers in my office and other defense lawyers were hammering out agreements and documents, trying to get things finalized. And it wasn't 3 o'clock, I guess, is when we got the word that it was on TV, that Mr. Branch was on TV telling the world what we were doing that day. And so I think Max had also broke it a little bit that morning, but Steve went into detail. Anyway, so that's how it went. I had a face-to-face with Michael Moore. He had maintained his belief and his position in this case, because I knew that Mr. Byers and Ms. Hobbs, and I didn't know Mr. Branch that well, but I knew that they were pretty vocal or had been on TV a bunch. I decided I'd wait till Thursday because, like I said, I didn't give them veto power.
Thanks, Scott. I'd like to go next to Patrick Benka. Most of you know that Attorney General Dustin McDaniel, who represented the state's interest and appealed vigorously opposed any relief for the convicts. But we now know from accounts that, and you can read in this week's Times, that the event that really put this in motion was a session that Patrick had with Dustin McDaniel, somebody he happened to have been close with in law school. So I'd like Patrick to talk a little bit about how in the world this idea took root, and then finally, do you think that only you could have been in a position to have that happen because of your association with Dustin McDaniel?
Well, first of all, I believe that the boys, I believe they're innocent. I thought that for a long time. And the only way that you would really know that is if you were to know these guys. They're pretty special kids. There's no question in my mind. I've been doing this for 15 years, and I know when someone's innocent and I know when they're not. And although I disagree with Mr. Ellington's position, I just want that to be known. These boys are innocent. I got on the case in January of this past year. Steve Braga, who was a D.C. attorney, who was the lead attorney in the case, he asked me to come aboard. I was very appreciative. And at some point down the road, we began discussing whether we could talk to the other side about skipping the new trial hearing that was set in December 5th. Because as we were preparing, we felt that the only issue that was clear as a bell was the jury misconduct issue. And if we were to get Judge Laser to consider that issue with regard to the new trial, we would win that outright. I did all the research, or actually not just myself, but also Mr. Braga did all the research, and we were convinced that if that issue alone was decided by the court, that they would get a new trial. So I approached Mr. McDaniel. He is a friend of mine. We went to law school together, and Mr. Braga and I spoke, and he asked me if he thought that Mr. McDaniel would listen, and I was hopeful that he would. I asked for a lunch date, and he accepted that lunch date, and at some point thereafter, he asked me what was on the agenda. And I told him to catch up, of course, and oh, by the way, I'd like to talk about the West Memphis 3. And he was agreeable to the meeting, and we met at the Little Rock Club, had a nice lunch, and then as coffee was being served, he turned to me and was waiting for my argument as to, or waiting for what I was going to ask about the West Memphis 3. So I lined out my argument, basically just sticking to the jury misconduct, and I tried to convince him that if the judge were to consider that, we would get a new trial. So, hey, why not skip the new trial part of this thing and let's get this thing set for trial? He told me at that point in time that he was not the man in charge, but he listened to me, and I really felt he did listen to what I had to say. And although he did use the words, "That's a big ask," I was very intimidated. I wasn't calm and collected as I was up until that point, because it's the Attorney General for the state of Arkansas. Although he's my friend, he's in a very high position. So he said that he wanted to outline my argument to him, just kind of reiterate it back to me. And I said, yes, that's what I'm asking. And he said, I will convey this, we'll talk about it, and I'll convey this information to Mr. Ellington, but I'm not the person in charge. And he did indicate, that he felt that the boys were guilty, and that was his position. So soon after that, he called me up and said we were talking about something, but in between that time, Mr. Braga and I myself just we started talking about, is there a way to resolve this case? Because we were thinking, okay, what if we get this new trial? There was an appeal possibility by the state on that issue that could have lasted a year. When we got the new trial, that would have been set for possibly a year after that ruling was affirmed by the Supreme Court. And then there was the unlikelihood, or not knowing how the jury would split if there was a jury trial. So we're talking about 3 years down the road, 3.5 years down the road. So Mr. Braga and I actually started considering, is there any way we can get them out sooner rather than later, with them maintaining their innocence? So we talked about a no contest plea, we talked about an Alford plea, And then by the time I received the next phone call from Mr. McDaniel, I indicated to him, I said, is there a way that we can possibly work this out? And he seemed kind of surprised, and he said, I can set that meeting up if you want me to set that up. And so from that point forward, he set it up the following Tuesday. We met at the Attorney General's office. I've met Mr. Ellington for the first time, met his staff, his deputies, and we sat across the table, and we went back and forth, and the agreement that we came up with that day was the agreement that we eventually signed on to. And as far as whether I was the factor, I don't know. I think the stars kind of aligned, and I think all the right things happened at the right time. I don't want to say that I played the role, but there was a lot of things leading up to it. But like I said, I think there's a lot more leading up to it than just me having a conversation with Mr. McDaniel.
Oh, sure. Thanks, Patrick. Next, if there's somebody in the room that's been associated with this case longer than Mara Leverett, I'd like to meet him, because she wrote about it first in 1993, I think, before the case went to trial. And so what I was going to ask Mara to do was, if she were a newspaper columnist again, to think in 700 words or so about how in the world this happened, how we came to this end, what factors influenced that happening. And then also, I'd like, as a personal question, I think I speak for a significant segment of the public audience, that there were a lot of people who were very solid with the idea that justice wasn't served in the way the first trial was handled. But that's a big difference between innocence on the part of the West Memphis Three. I know you came, like Patrick, to believe they were innocent, and how you reached that conclusion.
700 words, huh?
Well, it can be a little more. It can be a little more than that.
Okay. I think this, and pardon me, I'm hoarse. I think that the state of Arkansas set the stage for all of this, starting with the investigation of the murders and the questioning a month later of Jesse Kelly, where he gave a convoluted and distorted statement about the facts of the case. He made errors that the police knew were errors, and nevertheless, the prosecuting attorney was willing to go to court to have Damien, Jason, and Jesse arrested and charged with capital murder based on this very inaccurate statement given by a 17-year-old kid who had no lawyer or parent with him for something approaching 8 hours of questioning, only 2 parts of which, totaling less than an hour, were recorded, and in which he made such grievous errors as saying that the boys were tied with brown rope when in fact they were tied with their own shoelaces, that they were stabbed with their clothes on, but there were no stab wounds in their clothes, that they were raped, but that the medical examiner found no evidence of that. So, and also, very importantly, mentioning words about that suggested maybe some kind of occult activity. Right after he made that confession, and right after the boys were arrested and charged, and the police chief said that on a scale of 1 to 10, it was an 11. He was that sure of this case. The officials, we don't know who, leaked the transcript of the 2 recorded parts of Jesse's statement to the Memphis Commercial Appeal. From there, the word that this had something to do with Satanism and the occult spread, and a producer in New York at HBO saw a small article about it and handed it off to 2 filmmakers, well-known filmmakers, Joe Berlinger and Bruce Sinofsky, who came to Little Rock to cover the trials. It was because the prosecutor then was willing to go into that allegation that these were occult-related murders, that the trial took on, trials, there were 2 of them, took on such a sensational tinge. The judge, in a twist that was completely uncommon, I don't know that it has ever happened, allowed both trials to be recorded, filmed by HBO, and I think that made all the difference. The recordings of the HBO then, and Berlinger and Sinofsky made an excellent documentary film, Paradise Lost. As a result of that film and the incredulity that greeted it, people around the country and around the world who saw it could not believe that evidence had been presented against Damien and Jason at their trial. First of all, they couldn't believe that Jesse had been convicted on the basis of his own confession and nothing else, as the Arkansas Supreme Court noted in unanimously affirming Jesse's conviction. Then in the second trial, that Jason and Damien were convicted on evidence such as that Damien read books by Dean Koontz and Stephen King and Anne Rice, that he wore black even in the summer. There had been 11 black t-shirts found in Jason's bedroom, that Damien had a cat skull in his bedroom, that Damien had checked out a book called Cotton Mather on witchcraft. And the evidence like this was used and then was connected with testimony offered by a man who claimed to be an expert in the occult, although he offered no valid credentials of that. Judge David Burnett allowed him to be qualified as an expert witness, and he testified, well, John Fogelman, the prosecutor, one of the prosecutors, put into the record, first of all, asked the judge to note that there was a full moon on the night of those murders, and then this expert in the occult testified that there had been 3 victims, a highly symbolic number. There had been blood, there had been water, and even though there was nothing like pentagrams found at the scene or anything else, candle wax, anything real that could be connected to the occult, the prosecutor made the connection that these 2 things, Damien and Jason's interest in heavy metal music, the wearing the black and so forth, combined with the full moon and the number 3 and so forth, suggested that they were capable of doing this. And in fact, in closing arguments, John Fogelman pointed to Damien Eccles and said, if you look at him, you see there's no soul there. A point that has always struck me as reminiscent of the Inquisitions. And so this was vividly portrayed in HBO's film, and as a result, that film came out in 1996, just at the dawn of social networking and the internet. A website called WM3.org was started by 3 Californians, and they set it up. They made the tagline, "Free the West Memphis 3," and from there it spread and it spread and it spread, and celebrities got involved, and thousands upon thousands of ordinary people got involved. And I actually see what has happened in the past week as essentially a people's movement, that it was only because good media and a lot of people who cared so much about our justice system and about these 3 kids, with whom a lot of other people identified. I could not tell you how many people have written to me and said, that could have been me, or that could have been my child. So there was a lot of identification. A lot of people resonated with the First Amendment issues in this case. And they thought it was just flat wrong in this country, and they wanted to do something. People from outside the country thought it was wrong that this would happen in America. They were astonished. And so all of that taken together, money was raised, huge, huge, huge amounts of money for investigation, for the DNA that ultimately ended up going before the Supreme Court last year and resulted in the order for the new hearing. And that, as Patrick and Mr. Ellington have said, ended up with where we are tonight.
Thanks, Mara. I'd now like to turn to Blake Hendricks, who represented Jason Baldwin. Damien Eccles, because he faced the death penalty, probably became the dominant character associated with this case. But in a way, Baldwin's story is more remarkable. If you're familiar, in the original, he refused 2 opportunities for reduced sentences to testify against Eccles in the trial. He said he was innocent. We know now last week he balked for a long period of time at accepting this plea bargain because he didn't want to admit guilt to a crime he didn't commit. And I was hoping Blake could tell us about his decision finally to admit guilt, even though he said otherwise.
Max, it was not an admission of guilt, and let me say that the conclusion of this case is unsatisfactory. It's unsatisfactory to me, to my co-counsel, John Phillips, born in San Francisco, unsatisfactory to Jason. This thing had a quick lifespan of about 2 weeks, and to give you a quick background of it, as Patrick had said, apparently there had been some discussions going on that involved Eccles and the state. The Baldwin and Miss Kelly groups were not included in those, and frankly, we didn't know anything about them. So when a meeting got called on Tuesday the 9th at the Attorney General's office, and Mr. Braga, that represents Eccles, laid out this concept. Here's a way to resolve this problem. Here's a way to compromise this case. That was all new to Baldwin and Eccles, and I think Mr. Ellington looked up at me when I said, this is essentially the first time I'm hearing of this concept, and Scott was shocked. I think that the state had it in their mind that we were all coming in as a collective with this notion already in our minds, and that simply didn't happen like that. Mr. Rosenzweig and I were essentially hearing about this for the first time at that meeting, and what happened then sort of set the tone for the negotiations, and I said, I understand the concept that everyone is talking about. It does not seem to be thoughtfully done yet. There's not been apparently any attention to detail yet. I have no idea how my client will respond to this. But now that I'm at the table, let's begin to talk about the legalities of this, because you have to understand there was inherent logical inconsistency in the proposition that's being made. It's a 2-step process. First, the prior convictions have to be vacated. The only thing that was pending in front of Judge Lacer at that time was our DNA innocence petitions, in which we believed that we had presented compelling evidence of the innocence of all 3 of these young men. Then the proposal was, well, you have to vacate the sentence based on innocence. But how then do you expect these young men to turn around in essentially the same proceeding and plead guilty? It's illogical. It doesn't work. We need to, as lawyers, think through this process and exactly how we're going to get it done. And I think it's fair to say at that point, the Baldwin representatives sort of became known as the troublemakers at that point. A little bit of persona non grata. And so this very sort of long-winded meeting ended up with me simply saying, Eccles is on board, I understand. Miss Kelly is very, very likely on board. I have no idea how my client will respond. I will simply go to Tucker Max, sit down and talk to Jason and see what his response is. And so as we lawyers do, I met with my client. And I said, Jason, there are 2 options available to you. There's continued litigation, and I talked about the consequences of the decision to continue to litigate this case. And that John, my co-counsel, and I had the strongest confidence that we were going to win this case, that in fact we had, over the course of the 10 years that John and I, my co-counsel, have been involved in this case and assembled this evidence, that we were able to prove beyond any doubt that these 3 young men were innocent. Nevertheless, Jason, that requires more time. No matter the confidence level that I have, that hearing's not till December. All that December hearing means is if we win it, then we get a new trial, then we're going to trial, and we're years down the road, okay? The consequences then of the proposal that has been made to you, and it gets you out of jail immediately, but it's a compromise, Jason. You will have 3 murder convictions on your record, and you need to understand the consequences and make an intelligent choice here. And Jason simply responded to me, Blake, I cannot have 3 murder convictions on my record for something I did not do. And I told Jason that I was very proud of him, that he was a principled young man, and that's the man that I got to know over the 10 years of representing him, that he was a very principled, very intelligent young man. And I said, I will be proud to take this rejection back to the state. And so I did. And Jason rejected the offer. I communicated that to the state. The world became a slightly bizarre place for us at that time, because the proposition was a global proposition. If all don't take it, if one does not take it, there is no deal for all. So I know Jason talked to my co-counsel on the phone in San Francisco. They had a long, in-depth conversation about all the consequences of the choices that were available to Jason. It sat for 2 or 3 days. I actually talked to Mr. Ellington and made a proposal at that point. Listen, cut Jason out of this. Eccles, Miss Kelly want this deal. We don't want to screw it up for them. Let them take it. Just remove Jason from the equation. We can continue to negotiate with you on a possible resolution for Jason, or more likely than not, we will see you in December at this hearing that we have high degree of confidence that we are going to have success at. And again, the state's proposition was, no, this is global. It's got to be all 3 or none. 2 or 3 days later, I got word and went back and sat down with Jason at the maximum security unit. Part of the process that I think is important for folks to understand about how lawyers work, at least how I think good lawyers work, is we explain the consequences of the decisions and the options that our clients have available to them. And we give them our professional advice of the likely outcomes of these things. But what I've done since I was a young lawyer is also said, don't base the decision just on the advice of your attorney. You have trusted family members. There are people out in the world who you trust, and you trust their advice, and you should seek their counsel as well. It goes back to an old story. If I had a client that I assured, let's go to trial, I will win this trial for you. And he thought about it for 2 or 3 days, and he came to me and said, Blake, I don't want to go to trial. I want to resolve this case. And I said, what happened? And he said, I have a wife and 3 little girls, and I do not want to drag them through this mud. So people make decisions for various reasons, not just based on the advice of their attorneys. So Jason had obviously sought counsel from people he trusted, and I asked him, has something changed? And he said, yes. He said, from when you and I talked, Blake, I had not thought about Damien. And he said this. He said, I'm in prison on a life without parole sentence. That's bad. Death row is an entirely different creature. His exact words to me were, they want to kill Damien. If I don't agree to this, that could possibly happen. And so I've changed my mind, and I'd like for you to go make this thing work. And I said to Jason what I said to him when he rejected this. That's maybe one of the most noble things I've ever heard. I think you are an honorable, decent man, and I am proud to take this back and tell the state that we will accept this offer. The Alford plea, I know there's been a lot of what is this thing, and I will tell you, it is not as rare as some people think it is. An Alford plea is essentially this. It's an acknowledgement that there is evidence out there that if a jury believed could get you convicted beyond a reasonable doubt. But it allows you to maintain your innocence. And to put it in quick, there are 3 types of pleas that are involved in the criminal process. The guilty plea, the defendant acknowledges that there is evidence that could get him or her convicted beyond a reasonable doubt, and the defendant admits to it, confesses the act. Yes, I did that. The Arkansas Rules of Criminal Procedure recognize a thing called nolo contendere plea. Same foundation. There is evidence that exists that if a jury believed, it could convict me beyond a reasonable doubt. But the nolo contendere plea allows the defendant to then not admit the act. The Alford plea, which comes from a United States Supreme Court case in 1970, allows the defendant to go one step further. Yes, I recognize there is evidence out there that if believed by this jury could convict me beyond a reasonable doubt, but it allows the defendant to then deny the criminal act. In other words, to protest his or her innocence. Very simply, it's like this. Running a red light. I don't dispute that the cop is going to tell the judge that I ran that red light and that's going to get me convicted. The nolo contendere plea is, I acknowledge that, but I deny running that red light. The Alfred plea lets you go one step further. I didn't run that red light. So it's an unsatisfactory compromise. Alfred pleas are, nolo contendere pleas are. They are the practicalities of the criminal defense world and the prosecution world, and this ultimately ended up being an unsatisfactory compromise, legally done, but nevertheless unsatisfactory.
Thanks, Blake. Jeff Rosenzweig next. Perhaps I'm wrong, but from where I stand, Jesse Miss Kelly, your client, seemed the odd man out. He, when Damien Eccles and Jason Baldwin went to Memphis for a party at a fancy hotel, Jesse went home to very modest circumstances in Crittenden County. It suggests he was shunned by the other two defendants, perhaps because of the confession that was attributed to him early in the case. And why are we not to believe that confession, even if deficient in the facts, was not genuine?
Well, first, let me talk about Jesse and his relationship to the others. No, he was not shunned at all. Jesse essentially had not seen Damien Eccles for some 17 years, although Damien, of course, knew that Jesse had rejected an offer by the then prosecutor to cut his sentence in exchange for testifying against Damien. No, I didn't catch any shunning at all. Now, with regard to Jason Baldwin and Jesse, we sat together for, it seemed like weeks and weeks. Over a couple of years, we had a lengthy Rule 37 hearing in front of Judge David Burnett, which was on appeal at the Arkansas Supreme Court when this deal got cut last week. But Jason Baldwin and Jesse sat together in the courtroom for a week at a time, 3 days here, 4 days here. There wasn't any problem there. Jason is different in a lot of ways. Both Damien and Jason are very bright individuals. I hadn't really had much exposure to Damien because he wasn't part of our hearing setting, but I had some exposure to Jason. He's a very bright kid, very intelligent. Jesse is an IQ of 72. I think that may be about as, I think that may be a little bit generous in terms of what his IQ is. He is literate in the sense that a third or fourth grader is literate. He was, I think, socially promoted up to about the 9th grade when he sort of gave it up then. He spent a number of years on the host squad at the prison because he liked it, because of just the repetitive motions and getting outside. Highly unusual for a prisoner to do that. And then he transferred to the laundry, where he spent the last 4 or 5 years taking clothes out of the washer and putting them in the dryer. And that was his job. He just wanted to get home. His father was ill, has various medical conditions, and he was concerned about his father. He had had no exposure at any point in his life to anything of any sophistication. Yesterday, Blake and I took him he was in town because somehow his possessions ended up with us and not with his father. And he and a couple of friends drove him to town. We took him to the Oyster Bar, where he did not know how to peel the medium shrimp. And we had to show him how you peel a shrimp. But that's a nice kid, obviously has some extreme limitations, but not violent at all, just, childlike in a lot of respects, which of course was the basis of this entire thing, because the police exploited his childlike nature and fed him details and kept on changing facts, and so he could recite them. I pulled this up today, the direct appeal, the opinion that affirmed the Arkansas Supreme Court that affirmed his conviction the Supreme Court said, the tape of the boy's voice gives us pause. This is the type of tactic that comes perilously close to psychological overbearing, and we cannot condone its use. Well, that gives you some idea of the quality of the opinion, where they can talk about that and said, everything's fine. We affirm the conviction and life sentence. So now, dealing with the specifics of the statement, I think I sort of started with that. Yeah, he was, we know from 1993 to today, we know a whole lot more about the psychology of false confessions. It's the type of thing you see a lot of on TV or in articles about it. Much less was known about it at that time, and there was much less sort of general acceptance in the community that this was an actual psychological phenomenon. And there have been some other cases. I think the Norfolk Four in Virginia was one, and then I believe the one in New York and things like that. But there's a lot more social acceptance, and the exoneration by DNA of people who had, quote, confessed in a number of instances was another example. His lawyer, Dan Stidham, who did yeoman work on this case for years, originally thought he was guilty because when he had read the statement, and then as he got into it further, he realized that Jesse, in fact, was innocent. Now, as far as the habeas corpus petition was concerned, my co-counsel, Michael Burt from California, is a wonderful lawyer, as is John Phillipsborn, who is Blake's co-counsel. We felt that we were obviously in the toughest position with regard to the habeas corpus because we had the problem of all the evidence, the other evidence, of course, being the statement, in a way that the Eccles and Baldwin people didn't have, and that we were in the position sort of piggybacking in this proceeding on them. In other words, arguing, look, at the state's theory is that all three of them are guilty, and there's obviously clear evidence that Eccles and Baldwin aren't, ergo Miss Kelly has to be as well. But it was the type of thing that was going to be very tough for Miss Kelly to win on his own. We felt a lot better about the upcoming Rule 37 appeal. Our position is that I felt confident that we were going to be able to get a whole brand new hearing on all that in front of Judge Laser on our argument that Judge Burnett should never have been on the case, or at least not been on the case after he decided to retire from the bench and run for the state senate. And it was something that we raised several times without success. He said, well, I may not run, I may run, I may not run, who knows, I may move to California, whatever. And then I read in the paper one day, this was in 2009, a state legislative roundup of upcoming legislative races. And they said, in District whatever, retired circuit judge David Burnett says he's running. Well, we were only halfway through our hearing at this time. And so the next time we met court, I got elected to raise the point with him, and because it was sort of my idea, I guess, to some extent. And I raised it, and he eventually said, yes, I have told people I was running. Well, I found out later on that day the people he told included a rally that he had spoken at the night before. Anyway, but he denied it. He could be fair, et cetera, et cetera, et cetera. Well, then we went on, and we asked the Supreme Court to remand it back. They wouldn't, for more fact-finding, they wouldn't do it. And then we finished the testimony in the fall. And he set a briefing schedule, and then all of a sudden I open up the paper, and he's giving interviews to Jonesboro Sun, the Democrat, and an interview to John Brummett, in which, among other things, he's talking about the impact of this case. He hadn't, quote, made his decision yet, but he's talking about the impact of it on a state Senate campaign. So we fired up some more motions and everything, and he denied those without a hearing. So the record was just full of this issue, and we felt, or at least certainly I felt, that there was no way that the Arkansas Supreme Court in a case this high profile was going to affirm a decision made by someone who was, at the time he made it, a declared and campaigning candidate for a partisan political office. I just didn't think it was going to happen. This isn't some, obscure hot check case, and it just isn't going to happen. And so I felt that's where we were going to really get our traction. I had talked to Patrick the day before. The meeting was on a Tuesday, and I talked to Patrick on Monday, so I had some idea of what was coming. I was a little bit surprised at how apparently firm or how far along it was. I just didn't think we would get this far this quickly.
Thanks, Jeff. Finally, Cappy, thanks for being patient. Cappy Peck of Arkansas Take Action. You may not know she's also provided a home for Damien Eccles' wife, Laurie, for a number of years in recent years. It was a great moment of triumph last week. Not satisfied with that, she said immediately it would be time to begin a campaign to pardon the West Memphis Three. The governor's already said he's not much interested in that prospect, I think he's indicated. Realistically, first of all, I hope you can share, to the extent you're able, what the future holds for the three, to the extent that you're aware of it. But finally, realistically, do you think there can be the same fervor for a pardon campaign that there was for three people who were in prison, one facing death?
Most definitely, Max. And first of all, thank you. I'm a little intimidated with all these lawyers and journalists. I'm just a slinger of hash. But thank you. There is so much fervor. There's so much buzz right now. The big donors, the big bucks are saying, we're here, we're going to continue this. There's still DNA evidence that's being tested. The small guys, the people that send $5, $10 a month, we get emails, phone calls daily since the hearing on Friday that say, have you set up a trust fund? What are we going to do? We've got to help these three young men get their lives back, adjust to the free world. So I think that there is a lot of interest and a lot of passion and a lot of fervor. How that's going to look, I don't know. I've been reading, of course, what Governor Beebe's saying. We've had some conversation with Stephen Braga, Damien's lead attorney, who's out of the country on another matter briefly. He'll be going back. Arkansas Take Action, the grassroots effort that I helped co-found with Brent Peterson and lots of other guys. I see you, John Harden, Martin. I'm just the face here. There are so many people that have busted their butt for this, so I'm not alone. But we are not going to go away. We simply will not. And I can promise you that.
I want to try and speed up the tempo a little bit. I've got a couple of questions that I'm going to throw out. Everybody doesn't need to answer them. I'm looking for some sort of quick answers, and then as quickly as possible, after 2 or 3 more, then I want to go to the audience. But I want to raise the political question that's been raised. People, oddly enough, people on both sides of this, pro-conviction, pro-innocence, have said, oh, this was a political decision. It began with an elected state attorney general who set up a meeting, an elected prosecuting attorney who may have other elections in his future, ultimately signed off on the deal. And I'm interested at the notion that there could be political gain in this for anyone. I kind of thought I'd ask Scott about that and ask, why not play out the deck? Why not fight for the new trial? If a new trial was ordered, try to convict him and then say, and after all, you had nothing to do with the beginning of this case.
That's
Just
right.
play your cards.
Well, in January, when I took office, I realized that, the West Memphis 3 case is looming. You have one word for me, and that's looming. out there. I'm in a life raft, and I've got to get to shore, and there's a tropical depression, and maybe a hurricane between me and the shore. So I knew it was there. I began preparing. I appointed a deputy prosecutor to start researching the case. She went through police files, was going through appellate files, just about the same time that Misters Binka and Braga were coming on board on the Eccles team, is my understanding. So you have to understand, you have two lawyers, or two sets of lawyers, that are not, one is we're not intimately attached to this case as much as it's not personality, as much as it is working out a case at arm's length. I know that they're passionate about their side, and I'm passionate about my side. But we were fresh and new. When the proposal came in, I had given thought to this type of a resolution of some sort. What the heck am I going to do? And so when an offer came in like this, it was a bold decision on behalf of the Eccles team to propose it. And I think it was pretty bold on behalf of our side, and which, I mean, I had counsel of many, but they put my name on it because I'm the elected guy, and I had the final veto power of it, but I wanted to do it, and there's so many circumstances. We thought Judge Laser was headed the defendant's way. We thought that he would be granting a new trial, and we didn't know if that would be a year, 2 years, or 3 months. We anticipated it would be fast-tracked. And with the opportunity to leave the case with 3 guilty pleas per each defendant, even though they maintain their innocence, they plead guilty, that was very appealing. And politically, Max, I think I probably would have been better off letting the cards play out, taking it to jury trial, and then if we won, we won, and if we didn't, we didn't. But if we didn't win, I still had the same reasons why I entered into this agreement at the time. Evidence had gotten stale, witnesses' memories had faded, there were credibility issues with some witnesses, and I could see the first 2 defense witnesses. One would be Ms. Hobbs, and the next one would be Mr. Byers. And if you can't convince 2 parents that these 3 people committed this crime, then how can you convince not 12 jurors? I've got 36 jurors at this point, because you know that the judge would have severed the case. So I was looking at 3 jury trials in the next year, and it wasn't the timing as much as just for the state, it was the right thing to do. And if as far as the political implications, I would have been better off just waiting and riding the storm, and if I want to do something else later, just do it then.
Let me ask a quick question I've got to ask. If we roll back the clock and you went to new trial, would you raise the Satanism theme?
No, I don't think that I could do that. I think it would be, and I mean, you have to remember, I'm preparing for this case and going through appellate work and appellate briefs. I haven't gone through all of the West Memphis police file, and so I say no quickly. I don't see that happening, but, I never say never if we were. That's an advisory opinion. I'm not going to make it.
All right.
Max, can I say something, Max?
Yeah, go right ahead.
And with all due respect, Mr. Ellington, with all due respect, you talk about the probability or possibility of acquittal based on, I think you said, degradation of some evidence after 18 years and maybe the death of one witness. But what about the compelling DNA evidence? There's absolutely no physical evidence that implicates Damien, Jason, or Jesse, but there is that could possibly implicate 2 other people. The juror misconduct issue, the forensics, The tip line, thanks to Arkansas Take Action, where we got information placing Terry Hobbs with the kids shortly before they were murdered. What about all this evidence? It's just, I just, isn't that what would ultimately lead to the acquittal? The evidence and the lack of it?
Well, I'll tell you that the DNA evidence that you're discussing, that you're mentioning, Ms. Peck, is really not relevant at this time. The DNA evidence that you're talking about is granted, Bodie Labs did that, and there's no match to the defendants. However, there has not been a match. It was not run through any other systems to determine if it was any of the law enforcement officers that were at the scene, if it happened to be anybody that was at the crime lab. Remember, we've seen these pictures of the defendants using cell phones, and they didn't know what those were because we didn't have cell phones 18 years ago that was access for each of us. That's what the police department was using at the time. DNA was not anticipated at that time, and so there was no preservation. I will tell you this, the State Crime Lab has authorized me to say that when Bodie Labs finishes with the material, if they wish for the crime lab to run those results through the CODIS system, we will do that. And and that should tell whether it is either an employee of the crime lab's DNA that might have gotten there by being handed off during the process, because I'm sure rubber gloves wasn't the biggest deal back 18 years ago. And it will also, the CODIS system is also the system where felons are registered in this state. So they will run that through that system. I can't promise you that it'll all be, all the West Memphis police officers that were on the scene that time, that their DNA will be obtained, but I've been authorized to tell you that when Bodie Labs gets those results, the crime lab will run those through their system to assist in further investigation.
Thanks.
And Max, if I may.
Go right ahead, sure.
That's exactly the process that Jason and John Phillips Moore and I have been hoping for throughout this whole thing. The fact of the matter is that all the biological evidence that was obtained from this crime scene, none of it came from our defendants. There are foreign source DNA profiles at that crime scene. Some have been identified.
Yeah, Jeff,
If I
go right
can
ahead.
say something too. If I heard Mr. Ellington correctly, he said DNA was not being used then. I think that's an error. DNA was being used. It was much less sophisticated back then, but DNA was being used. The amount of DNA they needed to make for a sample was so much more than what is needed now, and you can pick up. This tests are so much more sensitive now. But the Arkansas Supreme Court got its first DNA case in about 1990.
Okay, I stand corrected. The sophistication, and maybe I should have limited it to West Memphis PD wasn't anticipating using DNA 18 years ago, as opposed to statewide.
Right. Let me, I want to ask
They
one.
didn't have computers back then.
Oh, go ahead. I'm sorry, excuse me. I want to ask one more question, then we're going to go to the audience. So if you want to get ready with the microphones and whoever else there, I want to ask one question that came to me from a reader, and it fits with, I've heard a lot of people say it, and everybody or anybody or nobody's welcome to respond. Would the attention given to the West Memphis Three been the same if they were black or Hispanic, listened to rap instead of heavy metal, if they didn't have rich people behind them paying for legal, medical, and other support? Would this have been a different outcome? And are they not visible because they're the right demographic versus a whole lot of other people in the system who might be in similar circumstances?
I'd like to speak to that. It's my view that the big divide in our country and in this state is economic. And in this case, In this case, these guys were poor trailer park kids. And that's where the question really ought to be, I think, would these trials have ever come out the way they did if they'd been the sons of doctors and lawyers and people of means?
Yeah, Patrick?
Or looking at the case now, if you had the evidence in front of you now that you do have, would these kids even be considered? And I think not. I think there's no question that they would have been excluded, and they would never have done. They wouldn't be where they're at today. So if you look at the evidence today and apply it as a prosecutor or law enforcement agency, these kids would have been excluded. They would have been back home, and it never would have been an issue. End of story. So that's.
Blake has a...
The outside funding in this case and the support that has been shown for these three young men is extraordinary. It allowed us as the lawyers, I tell you, at least from the Miss Kelly and Baldwin team, it didn't provide us much attorney's fees. We've been working free now for 8 years. But it provided us the tools in which we could affirmatively prove these kids' innocence. And I can't tell you how much we appreciate being provided the tools to do what we do for a living. Jeff and I, Patrick and I, we have cases that are like this that are not funded. Jeff and I were fortunate enough to get a guy off death row last year, but it was on a shoestring budget, and we were fortunate to be able to get that result. The system is entirely, and unfortunately, does not fund the quest for innocence, and that is unfortunate, and it does need to be changed.
So, thanks, Blake. I'm somewhat blinded by the light, but if you'll raise your hand if you have a question, the people with microphones will look for you to find you. And I'm counting on the people in the Skip for you to handle however we do that.
Okay, the first thing I'd like to say is that I've never been to any kind of venue like this, and I'm finding it quite educational, and I wanted to say thank you. The second thing that I wanted to comment on is what Mr. Baca had said. In light of the recent Casey Anthony case, no, these three men would never have been convicted based on what they had. I'm not sure how many questions I can ask, but I do want to ask this. Oh, man. Judge, the misconduct, the juror misconduct, I don't understand how that wasn't, why that was turned down, why Judge Burnett even sealed it. I don't understand that.
I'm happy to address the jury misconduct. In the context of what we are doing, as I told you, it was first necessary for us to vacate these prior convictions in order for this deal to get done. The notion was floated that we could do it on jury misconduct. It's a compelling claim. It is. But it does not include Miss Kelly. And so why that was not thought about during these negotiations, I guess until I raised it and Jeff raised it, was like, we've got to find a basis to vacate these pleas. It cannot be jury misconduct because it does not afford Miss Kelly relief. Do I believe that there was jury misconduct in this case? Undoubtedly, but it was a half answer to afford everybody relief.
Max, we have a question right over here. Let me get this question, then we'll come back.
Okay.
Mr. Ellington, you said just a second ago that you hadn't read the entire police files. How could you in good conscience actually have them sign on to be guilty if you yourself hadn't read the entire police files?
Two juries convicted these three men. The Supreme Court has affirmed those decisions. The facts set forth in the Supreme Court reports when the first decisions were affirmed. Most of this that we're here today on, or that we ended up in court last Friday on, were actually post-trial matters that arose out of the new DNA testing statute that was foreign. So my position is and has been is that 2 juries' verdicts affirmed by the Supreme Court are sufficient that I didn't have to read the entire police files. I was trying to, as we got ready for a new trial and got ready to go to court, of course, I would have to go through each item of paper, and that could have been as early as March or April or May of the next year. And we were in the process of gathering up the files and bringing them to my office. Like I said, I had a deputy that went to West Memphis Police Department and researched, started going through the files that they had there. So I'm comfortable and confident that we had good faith basis for this to take place.
Thanks.
Here we have, let's see, we have a question right here, sir. He's right here.
This one's for you as well. By not reading the police files and just basically going on, I can understand doing your job and trying to give justice to the 12 jurors for their decision as well. But what actually makes you believe that they're guilty? Because you've said that several times. So if you haven't read any proof and there is no evidence, what exactly makes you, Scott Ellington, think that these 3 kids did it?
Well, I've read the appellate work and I've read the appellate paperwork, and I do believe and that there's sufficient evidence of their guilt, and I've stated that previously. So I don't see any reason to start enumerating those things other than that after, and we're to the point now where I think that it's academic, so my personal beliefs are irrelevant at this point.
Let me suggest this. Scott got on this case in January. It landed on his desk. He didn't pick and choose this case. He did not prosecute this case. Brent Davis prosecuted this case. John Fogelman prosecuted this case. And Scott got left with what they did. I personally think Scott has acquitted himself very well during this process. He's been a gentleman to work with. He's been open and receptive to all the notions that we've talked to him about. There are some public officials that have been involved in this case that I will never vote for in my life again. Scott is not one of them. If I lived in Jonesboro, I would vote for Scott.
Okay, we got
If I
raising
could add,
hands here.
I agree with everything Blake said. I thought it took a lot of courage for Scott to do what he did. I disagree with him on the guilt innocence thing. I'm looking at it from my perspective. I see it's just innocence all the way, but we've got a very imperfect system, and I think Scott gave us about as much as we could ever expect, and still under the circumstances. And a couple things I think we also need to point out. Had Judge Laser granted a new trial, that would have been appealable if the state had wanted to appeal it, and that would have tied things up for another couple of years. And then you have the other issue, which is that federal habeas corpus, as a practical matter, has been completely eviscerated, and you can it is almost impossible now to win anything in federal court because of the standards. So we were dealing with what we were going to get in state court, and looking at procedures involving appealing. The state could appeal and get it tied up for a long time, and who knows what the Supreme Court would have done 2 years hence. So.
There's a far right, with their hand up, against the wall.
She's excited.
Thank you very, very much. I would like to ask a quick question in regard to the education now of these young men. Was Damien or Mr. Baldwin, were they either one, did they have access to education during these 18 years? And if so, could you share that with us if they're trained or educated in any way? Thank you.
Kathy, can
Well, they both have their GEDs. I think Jason's got, 30 some odd college credit hours. And Damien is one of the smartest people you'll ever meet. What's he going to do except read? It went 10 years in solitary. He's so well read. He's a gifted published writer. He's brilliant. He's self-taught. And you've seen Jason. Yeah, they had access. They're brilliant. They both are.
But Damien didn't have access to college credit or college courses on death row.
Let's see, we have a question right here. Yes, sir.
I guess my question concerns the real killers. I think that the majority of the people in this room, I suspect, feel that there are killers walking the street right now. I wonder, I guess I would direct it to my two heroes, Mara and Cappy, to elaborate on the pursuit of the real killers. Do you anticipate an indictment, and would that come sooner or later?
I'll talk to you if you want me to. I've said that we will, the DNA that was previously referred to will be run once Bodie Labs gets their reports done. The State Crime Lab has agreed to run those through CODIS, and that will, if there are any hits, then that evidence can be brought to the defense attorneys. I came prepared to say that I've been inundated with emails and text messages, and there were a couple of encouraging, nice ones. But I have also had correspondence with the defense team post hearings, and it's my understanding the defense team, and Cappy can correct me if this is wrong, but that there's a mechanism being set up in place, and I'm not going to receive any evidence from any of you guys out there. But if you can get it to the defense team and they goes through their screening process, then it can be considered. And what many of you probably don't know is Dan Stidham is actually a friend of mine, and there are people, I know there are people that come, one guy watched the movie one night, and the next week he bought a ticket he lives in San Diego or somewhere, and he bought a ticket and flew into Little Rock. He should have flown into Memphis, but he flew into Little Rock and rented a car and drove up there to talk to Dan to help solve the case. I know that many of you that are in here are not that type of person, but don't be bringing me any evidence. Take it to the defense team, and we'll let them set up. I've been advised that they're going to set up a mechanism to screen it, and at that point, I believe that the result that we have today is the right result. And I know you disagree with me, and I will maintain that I believe that these three men are guilty, but I will receive the evidence that's presented by the defense team once they go through that, and we'll have an open door. And that is an agreement that I've made with the defense team. Mr. Braga is a highly intelligent man. I do not plan on reopening this case, but I will look at the evidence. If it's compelling evidence, and it's run through the defense team, then it can be considered, but only through them.
Here.
Hi, my name is Sydney Shear. I'm a first-year student at the Clinton School, and I wanted to thank you all so much for being here first. I think I speak on behalf of all of my classmates when I say that this is a great learning experience to have so many different opinions and viewpoints here to speak to us about such a relevant and current topic. My question is really for anybody. I feel that in the light of this case, a lot of people, and a lot of young people, have felt really disillusioned by the justice system in our country. And I'm wondering how you would address that, and would you say that this will be a learning experience going forward? And what would you say to those people who kind of feel at a loss and maybe feel that the justice system didn't do its job in this case?
I'd like to say I think that the justice system didn't do its job in this case, and it hasn't actually yet. And it is very, very sad that as even the Judge Laser said in court, after all of these agreements after he approved them all, he said, I know it's complicated and it is unsatisfactory, but it's probably the best we can do. If this is the best we can do, we've got a lot of things we've got to correct. And I believe that I hope that one of the things that will come out of this case in Arkansas is that the great amount of interest and talent from very fine lawyers and investigators to a lot of ordinary people is that we'll be looking harder at our justice system. We'll be looking at things like requiring police to videotape interrogations from beginning to end so that a Jesse Misskelley confession can never happen again. We'll be looking at the way that appeals are handled so that a judge who's already announced his candidacy for political office cannot be allowed by the Supreme Court to continue to rule on a case that he's been sitting on for years and years. These kinds of things are just flat wrong. We're not stupid. We see that they're wrong, and I believe that it is because of the outrage among ordinary people that things have gotten to this point, and I think that outrage is going to continue and increasingly be directed at problems that need to be addressed.
And I need to butt in here, man. You know, it's not like me to be a moderator and not say anything, but I want to butt in on this on a small point and not to argue for the perfection of what happened. But I have one word for you when you look at the outcome in this case, and that word is Texas. Texas runs an assembly line to the death chamber. And whatever else happened here, and it took a long time, that didn't happen here. And I'd like to fill you in on a little something that's kind of an interesting piece of background. It's a young idealistic lawyer who was a law student in Fayetteville named David Mitchell, who wrote an influential law review piece about how the Supreme Court ought to consider the 2005 DNA law, which was supposed to tighten up the use of DNA in Arkansas. And he made the argument that it could be very expansive and it could be used in combination with all evidence available, not just evidence entered in the trial, but all evidence. And I don't know if he made it happen, but that's exactly what the state Supreme Court ruled. In most cases, a death case like this in Texas, they just rubber stamp it and say, get on to Huntsville. For whatever reason, despite all of the things that many of us feel were wrong about the handling of this case, in a unanimous ruling, the state Supreme Court of Arkansas took a very expansive view of what the court ought to hear in this case and ordered a new evidentiary hearing. That's why we're here today. So I just urge you not to despair of everything in the course of the system.
Okay.
My 2 cents, sorry.
All right.
Max, can I say something to the young woman who is disillusioned? I'm right there with you, but I have learned one thing, that ordinary people can make a difference, and I'm here to tell you that it's real. This is an extraordinary case. Without the Times and Mara and the HBO documentaries and the people that have been funding the DNA testing and the evidence, these 3 young men would still be incarcerated. But it took Arkansas Take Action, a group of just ordinary Arkansans coming together to help defeat John Hovelman and to put pressure on people to get this done. It's not the way we thought it would end, with a courtroom victory and real vindication, but we got people's attention. So it's your job to pay attention, and people do have the power. We can make a difference.
I suggest that you go to law school and become a criminal defense lawyer. I honest to God do.
Okay, we have a question right here. Yes, sir, right here. She'll get you the mic.
This question is for Mr. Hendricks. Mr. Hendricks, do you feel that man you represented, that he caved in to save his friend's life for the most part? Do you feel that that was the state's way of kind of holding Damian Echols hostage so that they could get the plea that they wanted? Do you feel that they were afraid to take this to trial because they actually might get another trial and be proven innocent?
All right, do I think that Jason was holding Damian hostage?
No, the state, in order to, because he had to take the plea.
I think that's a harsh way to put it. I can understand the state's position seeking a global resolution on this thing. It is efficient, it's politically efficient, it puts a bad case for a new prosecutor to rest. I genuinely hoped, and I can tell you that Mr. Ellington genuinely considered my proposal to cut Jason out of this deal. Do I think that the state took advantage of the principles of Jason? And I'll tell you, no, I don't think they did. To be honest with you, I've known prosecutors my whole life, and I believe that the prosecutors think that these kids are guilty. I, honest to God, think they do, despite all the objective evidence to the contrary. And so the notion of, and I'll just tell you the story, as one of the prosecutors said in this case to me at one point, the notion, Blake, of a criminal like your client having principles, I just don't understand it. You see the mentality? The fact of the matter is I don't believe that it was manipulated in that way. I don't know. I assumed that they thought, oh, this is a hell of a deal for all these kids. Everybody's going to jump on board. I think no offense, the Echols lawyers just sort of assumed that Jason was going to come on board. And again, it was one of the proudest moments in my career to be able to take the word back that this is a principled young man that will stick by his innocence.
Lady's back here's had her hand up for the glass right here. Yes, and she'll get you.
This question is for whoever has the information, but what happened to the story about the man who came into the truck stop all bloodied and they accepted the DNA and then lost it, or who knows anything about that?
The Bojangles. Jim?
Well, you go ahead.
No. Yep.
Well,
Alphonse.
Okay. Well, you know, I was always intrigued by that because this guy shows up at a time after the kids were missing and being killed, but no one really realized that they were. And they just, you know, it was, they did, apparently the police didn't take it seriously or they lost the evidence, and whether it was intentional or not. But, I mean, you have some guy shows up disheveled and bloody, you know, right near the scene almost immediately after.
And so bloody in the Bojangles bathroom that it's covered with blood. The employees don't have enough toilet paper to sop up all the blood in this. To me, the Bojangles is a perfect exemplification in this case that this is one of those cases that it's an entire systemic failure. The system entirely failed. The system failed from the law enforcement ground up. The system failed in how the prosecution treated the case. The system failed in how the state forensic people treated this case. The system failed from the defense lawyer's standpoint. It was a total systemic failure.
And just to be clear, that no forensic evidence was captured from this incident.
And furthermore, it was actually the discussion was brought up at both of the jury trials, the original jury trials by the defense attorneys about the Bojangles situation, and the juries did not cause them to have reasonable doubt in the guilt of the defendants.
And so it goes back to your position over here. And again, I encourage you to go to law school. There are a lot of people in my business that go around thumping their chest that this is the greatest system of justice on the planet Earth. I don't necessarily agree with them. I think it is a flawed system. And just like this case, there are failures across the board.
That's why we have appellate judges.
Beg your pardon?
That's why we have appellate judges.
But it took 18 years.
To correct it. So again, I encourage you. Being a criminal defense lawyer is one of the greatest jobs on the planet. I am shocked that I lucked into this job because my function is to balance power prosecutorial power over here. My job is to get up every morning and make sure, just like in our constitutional system of government, checks and balances. We balance power. When the power is out of balance, the system fails.
I would just like to ask that, in light of the fact that the West Memphis 3 took this plea agreement, the Alford plea, which I'm a third-year law student, my forte is not criminal defense, but I had never heard of this agreement. Will they be able to, since they're allowed to maintain their innocence, gain any profit from telling their story?
I meant to ask that question. There's some difference of opinion on this, I think.
I'm going to defer to Mr. Rosenzweig. I read an article in the paper that, where he was quoted.
Yeah, well, you know, you're talking about son of Sam laws and that type of thing. And our law, yeah, I think our law is unconstitutional. I think it's overbroad under the First Amendment. It talks about profiting from one's thoughts about the crime. It talks about reenactments. What, you know, you can see, you know, banning profit from reenactment. I mean, that's more of an offense against taste, I think, than anything else. But thoughts, it just sends up all sorts of First Amendment alarm bells. Secondly, but looking at it, even assuming it's constitutional, it talks only about the crime and would not prevent compensation for thoughts about, or about life in prison, the trial, comments on the trial, life beforehand, etc., but only about the crime. So I don't know whether it's going to end up being tested or not. I don't see, I personally don't see Jesse being involved in any deals, any publicity. He is not, that's something that he's just simply not interested in. He, frankly, is afraid that if he goes somewhere, someone will put words in his mouth, and since that's how this whole thing got started, does not want to repeat that situation.
Yeah.
Cappy, I wondered if you could elaborate to some degree, I don't know if specifically the question whether you know of any artistic effort is planned, but what life beyond getting used to freedom, I know that's the immediate short term, but what sort of life plans Damien and Jason might have?
I can't speak for Jason. I met him for the first time Friday, and it was a privilege and an honor. Damien, he's an artist. He's a visual artist, collages and other crafts. He's an incredible writer. His teacher, David Joust, I don't know if you're in here, although David Joust always says, I'm not Damien's teacher, he's my teacher. He has published a book called Almost Home. I know he intends to tell his story. Lori, his wife, is a successful landscape architect. She'll be able to provide for herself. He wants to tell his story. He wants to write. I think it's his journaling, his letters were cathartic. He wants to tell the story of what happened to him in prison for 18 years. It's a sad and tragic story. And I would like to make one comment. We have so many supporters that at first were almost disappointed at the Alford plea. They so wanted to see our day in court and true exoneration, and thought, well, could you just not stick it out? And you know, you're asking somebody on death row who's obviously in poor health, just looking at Jason and Jesse compared to Damien. You can see the difference. I think people are coming off that now, but you know, they can fight from the outside. They can fight a lot more easily from the outside than the inside. And both Jason and Damien expressed that to me time and time again this past weekend. They will fight to clear their names.
The last time I visited with Jason, he told me that he hoped to go to law school and not practice law. He hoped to teach, and he thought he'd be a good spokesperson for wrongful convictions.
All right, we have this lady, there's a lady in the back who's had her hand up very back against the wall.
Good evening. I appreciate you guys coming out here and speaking to the public. Jason is my cousin, and we prayed hard and long for God to give justice. And the question I have is, the plea bargain, does it not allow the West Memphis 3 to later on sue the state of Arkansas with an estimated $54 million for false imprisonment? Can you elaborate on that, please?
It's my understanding that with the plea that we entered, that would be that would prevent any lawsuits, and then there was a liability waiver that was part of our negotiated plea that was signed, where each of the individuals did sign a waiver of liability, and that was part of the agreement that we entered into. And those were signed along with the plea documents, my understanding.
See, I think this guy probably deserves the right to ask a question. Don't you think?
Oh, yeah.
Maura, we were talking about the problems with the justice system, and you've written about this code of ethics that exists amongst lawyers and judges, that it's not allowed for one to speak out negatively about another publicly. And, you know, in the case of Judge Burnett and the serial appeals that we had going back to the same court, you know, the question occurred when we didn't get to the second part of the first question the woman had about why was it put under seal, the jury misconduct information. And originally, the Supreme Court did that because there was a question about client-attorney privilege, because the attorney who came forward with this information was representing the jury foreman's brother on a separate case. So, you know, the speculation may have been, why did he continue to keep it sealed? And also, why did he not know that he had it in his office when it had been sent to him? You know, he denied ever having received it. The jury foreman is a real estate mogul, and this broaches another subject you brought up about the disparity of economic situations for people in this country, and that could be the biggest thing. You know, is that part of the deal? The guy's also was on the city council. He may still be, I'm not sure. And I don't know if he was being protected by the judge, but it just smacked to me of cronyism in that situation. And, you know, it just seems like this guy's become a state senator now, this judge. You know, a lot of us are grateful for that right now, because otherwise we might not have gotten to this point, at least. So I'm thankful for that. Yes, okay. And so what are you doing? I've heard that for a while the Arkansas Bar had a written evaluation of judges going on for a couple of years, but then that was abandoned. And do you know if anything else is being done in that direction? Or
The bar was what?
That the Arkansas Bar Association may have had a written evaluation about judge
I don't know. I don't know anything about that.
Okay, and I just wondered if you know of anything along those lines of the efforts of trying to change that kind of code, unwritten code.
I'll tell you that on the issue of the juror misconduct, that was actually litigated in, I believe, Mr. Eccles, one of his maybe Rule 37s, and the Supreme Court actually reviewed that. So that was a matter that was covered in, and it was still affirmed by the Supreme Court, as I recall.
Okay, everybody has been awful patient. I think we're about down to the last question point here, and Skip's going to look for the most worthy individual out there.
She's had her hand up since day one.
I would like to know, the state of Arkansas, you say, is so convinced that these men are guilty. What is it, them standing in front of a new judge saying that they're guilty, benefit to anyone to let someone off of death row and 2 other men out of prison? Who does that help other than them? That makes you believe so strongly that they're guilty?
Well, I think it's kind of back to the question we've had several times of how can you say they're guilty? And we've kind of been down that. I mean, I don't know if you want to do it again, but it's.
Well, I'm not going to comment on personal. The question that I thought might come is, well, if you say they're guilty, why could you agree to release them? And the answer to that question is that because of the juror misconduct issue that was bootstrapped up with the DNA, expanded DNA statute, the Supreme Court granted this new evidentiary hearing. I believe Judge Laser was going to grant new trials, and that would be 3 new trials, and they would begin probably, I anticipate he would fast track them. So it was better for, I believe, for the state of Arkansas, if you're in my position, to enter into this agreement where 3 individuals plead guilty and then leave with 10 years SIS over their head, and rather than being acquitted at a trial in the near future and walking out without any supervision. So that's why my position was that, and that's the reason I've taken the position I took.
Thanks, Scott. We're gonna call it to a close here. I want to thank everybody. Thanks, Skip, again. I want to give all the 6, first of all, a round of applause. And let me say, because I'm sensitive to this point, that we have not forgotten 3 children in West Memphis. And the outcome of this is no reflection of that. And I particularly want to thank Scott Ellington for being outbalanced on this panel. We tried to get some others, but failed in that effort, and he was brave enough to come, and so we're eternally grateful. Thank you, everybody, and good night.